Okay, so welcome back for our third and final panel. I was saying to nobody that it's amazing how we used to stretch these things into a day and a half in the olden days, and now we can get it done by, 3:30 in the afternoon. But it's been a pleasure so far, and I'm looking forward to this last panel. I'm going to introduce each speaker or set of speakers just right before they speak. I believe my colleague Aziz Haq is leading the presentation for this paper, but I'm not sure. But I'll introduce all of the participants in this project. So I think if you look up the word polymath in the dictionary, you might find a picture of Aziz. His teaching and research spans a huge number of topics within the law that would include constitutional law, criminal procedure, federal courts, legislation. And in particular, he's interested in questions about the interaction of constitutional design with individual rights and liberties. His three collaborators on this project are all from the Stanford Computational Policy Lab. Alex Chohlas Wood, who I can see is here with us today, is the executive director of the lab. He was previously the director of analytics for the NYPD. And Sharad Goel is the founder and faculty director of the lab, teaches in the Department of Management, Science, and Engineering at Stanford. And his research covers a pretty diverse set of contemporary social issues through the lens of computer science. So I'll let whoever is giving the remarks take over from here, and I'll be back later.
Thank you, everyone, for sticking around on a Friday afternoon. And thank you very much in advance for the feedback on this project. I want to thank in particular, or actually apologize to Joe Bloker in particular. Only when I looked at the schedule this morning did I realize that we hadn't placed a University of Chicago person last, which I think is usually the courteous thing to do, and we have somebody who's a guest right at the end of the afternoon, which had I been paying more attention to the way that the schedule had been organized, I would have prevented that, and so I apologize for that. Okay, as John said, this is work that comes out of the Stanford Computational Policy Lab. I should confess up front that I'm something of a free rider on their labor, although I've worked with Sharad and Ravi on Chicago-related data in relation to a project with the ACLU. The aim in this paper is to offer a number of different empirical strategies for identifying and evaluating what we term unnecessary or discriminatory police violence. The key term here is unnecessary, and it requires a definition. Unnecessary is an evaluative term. It implies a baseline against which the necessity of a specific policing tactic is measured. I'll start out by setting out a normative framework for thinking about that baseline problem, specifically linking it to a couple of ideas in the law which provide useful analogic frameworks. And then Alex will turn to three particular specific tests for unnecessary and discriminatory policing that we present in the paper. And then we're going to open things up in the paper, but not in our presentation, to a number of questions about the scope of application and the limitations of each of these three tests. And we welcome feedback both on the general picture and on the particulars of the test. Policing often involves violence. It therefore requires a justification. Where this violence is disproportionately experienced at a higher per capita rate by a racial minority, policing imposes a social cost in terms of increased stratification over and above its normal toll. Hence, the justification that's required for racially disparate police violence is arguably greater than that warranted for symmetrically or evenly distributed police violence. There are therefore several different ways of conceptualizing the problem of unnecessary police violence. Now, one possibility that we are not going to pursue, but that is extremely important, is the kind of systemic approach that was on the table this morning in the analyses by Allegra, Pat, and Rob. We think that is an important approach. We think that the policy-specific approach that we take here is complementary. It's a way of gaining traction by identifying especially harmful and unjustifiable policing measures and showing concretely both the nature of the harm and the absence of offsetting benefits. So to think about this problem, we put on the table two different legal frameworks. These frameworks are not, for the most part, directly applicable to the policing context, but they provide a helpful intellectual frame. The first of these is the cost-benefit analysis framework that's set forth in the Executive Order 12866 that was first promulgated by President Reagan, but then preserved by President Clinton. Pursuant to the older cost-benefit framework, the regulation is evaluated by inquiring into the full spectrum of benefits and then taking the costs of the regulation into account. The second executive order that's mentioned on the slide is a Trump-era order that modifies it, which we'll need to talk about and explain the irrelevance of in the paper. In approaching or in applying the cost-benefit analysis framework in the policing context, we assume here that there are costs associated with coercive encounters. We assume those costs to be substantial. However, the approach that we take is primarily focused upon identifying a category of policing tactics where there are zero benefits. So we're identifying the minimal category of unjustifiable, unnecessary policing tactics, but that category is necessarily larger. The second framework that we adopt is called the Disparate Impact Framework. Originally developed by the Supreme Court in 1971 in a decision called Griggs versus Duke Power, disparate impact was initially used as a doctrinal device for flushing out the lingering effects of Jim Crow in the labor market. It was then extended to other statutory frameworks, including, most importantly, the Fair Housing Act, the Age Discrimination and Employment Act, and it's further been adopted into state law in both California and in Illinois. And I would flag that in both California and Illinois, it is arguable that policing measures are a form of state action that is constrained by the disparate impact norm that I'm about to describe. So for simplicity's sake, this is going to be the next slide, Alex. For simplicity's sake, let's focus upon the disparate impact framework under Title VII of the Civil Rights Act. The Fair Housing Act framework was substantially altered by a Trump-era regulation. That regulation's been enjoined, is in the process of being rewritten by the Biden administration. Title VII is just a cleaner analytic analogy. So disparate impact pursuant to Title VII requires that a plaintiff start off by identifying a per capita difference in the treatment between a protected and a baseline group of at least 4/5. It then limits liability to instances in which there is no business justification, no firm-specific justification, or where there is an alternative policy with a smaller racial spillover. In effect, disparate impact defines and then operationalizes a race-sensitive concept of necessity. So translated to the policing context, we might say that a tactic imposes a disparate impact in an analogous sense if it creates an excess of costs to racial minorities in relation to a similarly situated white group. The concept of similarly situated, which Alex will explain, impounds in the second and third term of the disparate impact doctrine. The third and final question that we want to put on the table concerns circumvention. This is the possibility that a state agency will respond to the reform of one policy by making changes to a second and closely related policy. Any gains from the first policy's reform might be offset or even made worse by the change in the second policy. So that's three different questions that we have on the table: cost-benefit analysis, disparate impact, and circumvention. I'll turn things over now to Alex to flesh out the empirical tests that we would suggest for each of those three.
Thanks, Aziz. Great. So as Aziz mentioned, I'm going to go over three different strategies that fit into these, or at least are strongly associated with these legal topics. The first is this notion of cost-benefit analysis, and in particular, situations where there is no apparent benefit, at least as stated under the policy goals. And this comes out of, there's a concrete example that I'll show that comes out of an engagement that we had with the city of Nashville. Second, I'll talk about situations where we can compare apples to apples, so to speak, to understand whether there are different standards for treatment, or essentially that there may be a sort of evidence of disparate impact, even aside or outside of that context. And this is now from the city of New York under the stop and frisk policy. And then finally, I'll move and talk briefly about a situation that came up in Chicago, where it appeared that reforms that were taking place were actually, in some sense, displaced into other tactics, where at the end of the day, the impacts on communities of color really didn't change much at all. And I should mention, this is work that's been developed in our lab. I just want to recognize also that many others sort of in the lab have been involved in this work, including Marissa Gerchek, Robbie Schroff, Amy Shoemaker, and Kenyo Yao. And one final thing to note here is that these three strategies, I don't want to give the sense that these are the sort of three comprehensive strategies for understanding this notion of disparities in policing. These are just three strategies that we've developed in these particular scenarios that we think could apply in other contexts, but don't want to sort of get the impression that this is the entire set of strategies that one could use to understand disparities in policing. Okay. So first, I'm going to move to Nashville and thinking about the cost-benefit analysis here. And so first, I'll talk just sort of on the cost side. For context, the city of Nashville, really over this 6 or 7 year period, a few years ago, the department in Nashville, which is known as the MNPD, conducted up to as many as 10 times as many stops per capita when compared to similar American cities. Pretty extreme rate of traffic stops. And associated with this policy of conducting these stops, it turns out that Black drivers were stopped significantly more often than white drivers, particularly for this class of violations that we call non-moving violations, which include things like a broken tail light or expired tabs on your license plate, things like this that aren't about strictly about speeding or other kind of dangerous traffic behavior. And so just to quantify this disparity further, we see that in 2017, in the most recent year, in the analysis that we conducted, the per capita stop rate for these kinds of violations for Black drivers was 70% higher than for white drivers. So significant disparity that we observed. And these disparities were even bigger earlier in the policy when there were more stops being conducted. So I think I think we can all agree on the fact that there are significant costs associated with this kind of policy, and in particular, it appeared that the costs of this policy were borne in particular by the Black community in Nashville. So this was no accident in some sense. The department justified this policy by saying that this use of traffic stops was a crime-fighting tactic that should be concentrated in high-crime neighborhoods. And in Nashville, like in many cities, there's this association between neighborhoods that are largely Black and crime rates, recognizing that that's a product of historical neglect and many other sort of historical discrimination factors like that. And so the sort of justification was that, well, they're conducting these traffic stops as a crime-fighting policy, and they should be concentrated in these high-crime neighborhoods, and that's why these disparities are appearing. So the question we asked was whether this benefit was being realized, whether these stops were actually an effective crime-fighting tactic. And we looked at the historical data over this time period. One thing I'll note is that we did a sort of expansive analysis of this question of whether these stops were effective at fighting crime. The one chart I'll show you is the easiest or sort of most intuitive result that we found, but there were more complicated and involved analyses that we did as well. Okay, so what I'm showing you here is over the time period, which is on the x-axis from 2011 to 2017, the per capita rate for these specific kind of stops, these non-moving violation stops. And we see that at the beginning of the period, in 2012 in particular, that per capita, or per 1,000 people, there were almost 400 stops per year. So in other words, a pretty significantly high rate of these stops being conducted in the city of Nashville. But by the end of the period in 2017, it appears that the stop rate has been halved. And so you can imagine that if this tactic is an effective crime-fighting policy, that this withdrawal in some sense of this policy would result in a rise in crime. We would expect that if this is effective, that taking it away would mean that crime rates would go up. But in fact, over the same period, what we see is that there's no really observable change in crime over the same period. This is the index crimes that are considered to be Part 1 crimes. or even sort of more specifically focusing on violent crimes, which were stated as a goal of the policy of fighting violent crimes in particular, that these rates were steady as well. And so we don't see the kind of connection that you would expect to see if there was a strong association between this tactic and the crime levels in general. Okay, so the takeaway here is that there's not a connection, and we show this again through several other different approaches, that there's no apparent crime fighting benefit to conducting traffic stops, and in particular these non-moving violation stops. And so as a result, the sort of outcome from this side of things is that if we don't see a benefit and there's significant costs, in particular disparities that are borne by the Black community, that the city should significantly limit the use of such stops. And just for some context here, the analysis that we did was in the larger context of pretty significant public pressure from community groups that had happened across this entire time period, saying that these disparities weren't justified. And in response to that public pressure, the department further reduced the use of these kinds of traffic stops by 75% after the numbers that I showed you, and again, didn't see any associated rise in crime. Okay. So that was for Nashville. Now I'm going to move to New York City, and slides are taking a leg and a bit here. Okay, so in New York, moving to now the stop and frisk context, the stop and frisk program that I think probably a lot of us are familiar with. This was a program that in particular peaked in 2011 with the widespread use of stop and frisk, millions of stops as part of this program over the entire course of the policy. And as in Nashville, there were significant disparities associated with this program, in New York in particular for Black and Hispanic residents. So one question that I think comes up a lot when you see these kinds of disparities is potentially there's a motivation for these disparities in the sense that you might have individuals in certain groups that are potentially riskier. And so the disparities in these enforcement corresponds in some sense to differences in risk between these two groups. And this also aligns with the notion of the use of a frisk in particular as something that's legally justified as a way of recovering weapons and protecting officer safety. So the idea would be, we see these disparities, but the police department, for example, might argue that these disparities are justified because certain racial groups tend to be, on average, riskier than other groups. So what we do in this analysis is we say, rather than sort of having this apples to oranges comparison that's implied by the sort of raw statistics or the raw disparities, let's actually try and adjust for this difference and now purely look at the risk to officer safety. And how can we do that? The way that we do that in this analysis is we estimate the risk to officer safety by observing in historical data how often weapons were recovered after a frisk. And once we know once we sort of observe these historical patterns, we can say, here's two similarly situated individuals based on the things that are observable before the frisk happens. These individuals appear to be the same risk for having a weapon. And then we ask whether the outcome for these individuals is the same. Essentially, we ask whether they were frisked at the same rate. And sort of conversely, if we see that similarly risky individuals who are just as likely to have a weapon in different race groups are indeed frisked at different rates, that suggests that the delivery of this policy, the implementation of this policy, has unjustified racial disparities. Okay, so now turning to the sort of quantitative results here, what I'm showing you is a spectrum of risk. And right now, this is only for white individuals who were stopped. This is sort of a population of people who were stopped. And I'm showing you what happens for different white individuals, depending on their estimated risk that we've done in this sense. So just to make this concrete, here I'm showing you a single point for a white individual whose estimated risk is 2.5%. What we see in the historical data is that white individuals with this estimated risk were frisked about 50% of the time, about half the time. So we see that individuals at this relatively low end of the spectrum, white individuals with this estimated risk, were frisked about 50% of the time. And now conversely, what we see for Hispanic and Black individuals is that individuals with the same level of estimated risk, essentially the same level of risk to officer safety, were actually frisked in practice at much higher rates. So for Hispanic individuals, that's something like 2/3 of the time. And for Black individuals, it's something almost 3/4 of the time. And what we see also is that this doesn't only hold at 2.5%, but really across the entire spectrum here of risk, we see that the Frisk rates for a given level of risk is generally higher for Black and Hispanic individuals, regardless of the actual risk that we estimate. Okay, so the takeaway here, again, sort of getting back to the fundamental problem, is that a big challenge in assessing these kinds of disparities is that you have individuals from different groups. You might have this apples to oranges issue in that you don't know if the contexts are the same. And we demonstrated that there's an approach that you can take to try and equate individuals on the stated basis of the policy, in this case, the risk to officer safety, to see indeed if these disparities persist even when you control or adjust for this goal. Okay, so now one last note about taking a holistic perspective, which we use Chicago as an example. So in 2015, the city of Chicago, or in particular the Chicago Police Department, entered into a settlement agreement with the ACLU intended to reduce the use of pedestrian stops. And historically, you can look back after this was implemented. We do indeed see a dramatic drop in these pedestrian stops. Really sort of the intent of the agreement. But unfortunately, at the same time, what we see is that there was also a concomitant or associated rise in the use of traffic stops. And in particular, at the end of the day, if you sort of look at the entire evolution of these two policies happening, one where pedestrian stops are going down, one where traffic stops are going up, at the end of the day, the disparities on communities of color persisted even through these changes in these two policies. And this closely aligns with the study that just came out from Hausman and Kronik, which details this in more in detail. Okay, so just to show this graphically, first what I'm going to show here is the use of pedestrian stops. And we see that after the settlement agreement went to effect in 2015, indeed there was a pretty dramatic drop in these pedestrian stops. And this is really the intent or the focus of the settlement agreement is to monitor the use of these stops in particular. But now if we take a sort of broader view and we look at what's happening with traffic stops, we see that there's some sense of compensation or even displacement in the policy where now traffic stops are being used almost at the level of pedestrian stops as they were being used something like 7 years ago. Okay, and now sort of just to take this in a different light, we can also look at the racial disparities over the same period, and we see initially that the settlement agreement was associated with this pretty big drop in disparities for the Black community in particular, but also for Hispanic individuals in Chicago. But now, as traffic stops have resumed or increased, the total disparities in stops among both traffic stops and pedestrian stops seems to have returned almost to the levels that they were before the settlement agreement went into place. And so I'll end here just by noting for Chicago that the sort of notion here is that these reforms often are intended well, but the scope of analysis in particular can often be too narrow, and any kind of analytic effort that's associated with these reforms should consider a more holistic perspective, in particular ways that these policies might mutate into new kinds of outcomes and really very little change for communities of color at the end of the day. Thanks.
Thanks very much. I also want to apologize for missing some of the participants in the project when I did the introductions. Marissa, Amy, Ravi, and Kenyal, who I see are here with us today. Welcome to you. I didn't mean to overlook you. I just didn't have a complete list of project participants when I did the introduction. Okay, so our second panelist is LaToya Baldwin-Clark, who teaches at the law school at UCLA. And before she moved out west was a Dickerson Fellow at the University of Chicago Law School, had the office right next to me. I miss her, it's nice to see you. She is trained as a lawyer and a sociologist, and she writes and teaches about education law, family law, property law, and race and discrimination. And she's going to talk about school segregation today. So take it away, LaToya.
All right, thank you so much for having me, and hopefully everyone can hear me. So I've titled this project, Killing Me Slowly, Structural Violence in Black Children's Lives. So these are video or pictures of children who were killed in Chicago in the summer of 2020. Their names are DeJory Wilson, Natalia Wallace, Makai James, Janari Ricks, Lena Nunez Anaya, and Sincere Gaston, all under the age of 10, each of them shot to death in Chicago in the summer of 2020. In August of that same year, a journalist put at 38 the total number of children who have been killed by gun violence in the first 3 quarters of 2020. A more recent April 2021 CBS Chicago article noted how the number of Black children being killed by violence, gun violence, topped last year's numbers at this time. And this article was published very shortly after the murder of 7-year-old Jaslyn Adams on Chicago's West Side. So Black children suffer astronomical rates of gun violence. According to the Children's Defense Fund, gun violence is the #1 killer of Black children and Black teenagers. More Black children died by gun violence than white children in the 20 years ending in 2019. And the Black rate per 1,000 children of firearm deaths is 7 to 8 times that of similarly situated white children. So this reflects the impact of direct violence on children's bodies, the literal killing of them as individuals. But in this essay, I argue that this is also about structural violence that makes Black children in Chicago and other major cities susceptible to this direct violence. Structural violence inflicts its own slow death that accompanies constrained life chances and choices, starting when children are very, very young. The structural violence embedded in Chicago can be seen in the general health of Black people in the city. You compare the life expectancy by Chicago neighborhood. The darkest grays on the left are the majority Black areas, and the darkest grays on the right are the lowest life expectancies. Life expectancies in predominantly Black communities and neighborhoods on the south and west sides of Chicago trail by over a decade life expectancies in the city's predominantly white neighborhoods. This is one of the effects of structural violence. So what is structural violence? I take this from an article by Adamson, Menjivar, and Walsh, who were commenting on the work of John Goltang, who first came up with the idea of structural violence in peace studies. So structural violence refers to the uncertainty and suffering that results from the systematic marginalization of people with limited access to state services. It's often not observable in specific events, but rather the result of larger processes. And we call it violence because it constrains opportunities and severely undermines life chances. As such, it can lead to the slow death I referred to earlier. So structural violence differs from what we might call direct violence. So direct violence is this individual physical violence that works on the body. In direct violence, there's a subject, there's an object, and there's an action that causes injury to that object. This type of violence we generally believe to be aberrant and deviant. And we arrest perpetrators, we prosecute them in courts, and we sentence them to prison. But structural violence, on the other hand, works on the soul. It affects the possibilities for the future and decreasing potentialities. It's the difference between what and where one could be and what and where one is. And perhaps most importantly, structural violence is highly normalized. We seem to be comfortable with the fact that, for example, educational opportunity is stratified by race, class, and in particular geography. It's normalized in the general acceptance of the current structures of subordinating institutions such as schools, employment, higher education, neighborhood health, and health care. It's also in a sense that these stratifications may be reasonable for one reason or another, or in a sense of resignation that there is nothing that we can do. And of course, direct violence can also be structural violence, as we can see in police shootings and state violence and the laws that surround them. So structural violence, again, not always observable in specific events, but are systems that distribute injury, sickness, and death to the disadvantaged. It's a group-centered victimization, not always with the direct perpetrator, which results in unequal life chances, inequality, subordination, and oppression. So often, when we think about violence and perhaps how they work on children's bodies, like the children that I started this presentation with, the newspapers, whereas I get a lot of my information, as I'm sure you do as well, really focus on direct violence. But what structural violence does, it helps us understand the overlapping systems of oppression and stratification that work to constrain young people's life chances. So, where a child lives, where they attend school, um, how they are policed, they all work together that can actually make children more susceptible to gun violence, as well as the slow death of decreased life expectancies. In the essay for this symposium, I plan to focus on the structure of schooling, which is where my expertise lies. But I also think that education is particularly interesting to study here because the country made a really big promise to Black children in Brown versus Board of Education when it claimed to strike down school segregation on the basis of race. In the opinion, Chief Justice Warren explained the particular dangers of school racial segregation, saying that without integration, education, these children would not have it as the very foundation of good citizenship. He wrote that it is today a principal instrument in awakening the child to cultural values and in preparing him for later professional training and in helping him adjust normally to his environment. And most importantly, in these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Unfortunately, in 1974, a mere 20 years after Brown, the court said that while Brown held that segregation by race is wrong, segregation by geography and residence is just fine. To bypass integration, white parents flocked to racially segregated schooling in the suburbs, abandoning many of the central cities. They erected boundaries between school districts and often between schools in the same district. Although these borders may look like an artificial and nondescript avenue, the court in Milliken v. Bradley rendered those boundaries as sacrosanct, saying, boundary lines may be bridged where there has been a constitutional violation, calling for inter-district relief, but the notion that school district lines may be casually ignored or treated as an administrative convenience is contrary to the history of public education in our country. And why is that? It's because these boundary lines are foundational to what the court called the most deeply rooted tradition in public schooling, local autonomy. And indeed, those boundaries are not administrative conveniences, but rather socially constructed, reified, racialized, and police borders and boundaries. State education law does actually require children to be residents in a district's boundaries to be able to benefit from that district's schools. And this is a phenomenon I wrote in a piece called Education as Property, and also a piece that is forthcoming this summer called Stealing Education. I show that white parents study these school district boundaries when deciding where to live. And indeed, that research shows that white parents choose their residences on the basis of school racial demographics, resulting in a preference to be in areas and attend schools where there are few Black students. Now, state law allows municipalities to hoard these vital educational resources for their children at the expense of other people's children. And actually, by passing laws that allow for the violent threats inherent in the criminal justice system, private investigators paid by the state to survey and target parents, and even deputizing private citizens. In Illinois, when this law was passed in 1996, it was lauded threateningly as the teeth of a tiger. These are racialized processes, as I show that while residence is a category that is race neutral, it is often used as a dog whistle for race. Now, in dissent in Milliken, Justice Marshall predicted that these boundaries, protected by law, would deny Black children an equal start to life and to an equal opportunity to fulfill their full potential as citizens. He conceptualized these boundaries as fences thrown up to deny Black children the right in the future. So, like him in this article, I want to harken back to the moral promise the country made to Black children in Brown to argue, as Justice Marshall did, that those fences that are thrown up around a city or around a school district are a layer of structural violence that denies equality, constrains life choices and life chances, and ultimately leads to the slow death that results in lessened life expectancies determined by residents. So, what would be the answer to this structural racism? And it's a question that really animates most of the work that I do and what I'm trying to kind of figure out. Well, Professor Elizabeth Iglesias says that the critique that is implicit in the concept of structural violence is a commitment to structural justice, or one might call structural peace. Defined here as a commitment to the evolution of institutional arrangements whereby the domination can be effectively transformed through the agency of those whom society subordinates. And I think this moral commitment is strongest when we're considering the youngest among us. So, in sum, I titled this piece Killing Me Slowly to refer to these structures of oppression that distribute opportunities geographically, as in the case of school districts, and that leave Black children stuck, both figuratively, as they're stuck in their place in the social hierarchy, then also being subjected to these oppressions of violence, as well as being literally stuck, as previous panelists have suggested, that the fences to educational opportunities are both barbed and electrified through the deputizing of criminal law and threats of punishment for transgressing these lines. And within those fences, the inability of a child or a young person or a family to exercise their agency to leave that neighborhood also means that they are unable to protect themselves from the direct interpersonal violence that we all see, that it is now reported on the news. Thank you.
Thank you, LaToya. So our last speaker of the day, but remember, we have Q&A after he finishes speaking for all three of the speakers on this panel. It's Joseph Bloker. He's a law professor at Duke Law School. He's one of the Legal Academy's leading experts on the Second Amendment. And his other research interests include federal and state constitutional law, the First Amendment, in particular free speech, legal history, and property law. And he's going to talk to us today about preemption and state laws that preempt local efforts at gun control. Take it away, Joseph.
Yeah, thanks very much, John, for the really generous introduction. Thanks. Since I am last, I take prerogative to thank, on behalf of all of us, thanks again to you, to Aziz, and especially to all the students and staff who've put in so much great work to make this symposium go off as smoothly as it has. I've learned so much throughout the day. I'm really, really honored to be a part of the conversation. As John mentioned, my primary research interest, at least as relevant to today's discussion, is gun rights and regulation, and the forms of what LaToya was just talking about is direct violence. So my focus here will be on particularly gun violence and specifically gun homicide and the distribution of regulatory authority among federal, state, and local governments when it comes to trying to address that problem. But the project actually starts with an even more simple observation, I say simple or straightforward observation, one that I think will be a surprise to nobody, or nobody here anyway, which is that the majority of Americans live in urban areas, and the vastly disproportionate number of gun homicide victims die in urban areas, despite the fact that gun ownership is much less common in cities than it is in rural areas. Some statistics here, none of which is original research of my own. These are widely available empirics. The last numbers I saw for Chicago said that of 770 homicides in the city in a given year, 620 were gun homicides. And it seems that in most years, it's between 80 and 85%. I also want to echo and amplify something that LaToya said, which I think is worth emphasis, which is that most of the victims, not just a disproportionate number, but most of the victims of these gun homicides are young Black men. and that's consistent with national trends, where about 70% of urban gun homicide victims are Black. It's also worth noting that support for gun regulation also tends to be much higher in cities. By some measures, it's roughly twice as high as it is in rural areas. And yet throughout the country, and Chicago is actually a little bit of an exception here, I'll come back to this in a minute, cities consistently regulate guns less stringently than it seems the residents would like them to. So the question is, well, why might that be? There are obviously political explanations for that, and I'm happy to talk about the sort of pathologies of the great American gun debate, as it's sometimes called. But I think it would be a mistake to look past what might be legal obstacles to urban gun regulation that might help explain that regulatory gap between apparent voter preferences and what we see in terms of regulatory outcomes. Now, in terms of legal obstacles, of course, the most obvious one, the one that people talk about the most, is the Second Amendment. And given that our focus here today is on Chicago, I just want to emphasize what a central role Chicago has played in the development of modern Second Amendment doctrine. Most people, when they talk about the modern Second Amendment, I think immediately think of the Supreme Court's decision in District of Columbia versus Heller, which is deservedly credited or blamed, depending on your priors, for having given the right to keep and bear arms sort of new meaning as this often called individual right to keep and bear arms against criminal threats in particular. But as a practical matter, the more important decision came 2 years later in Mcdonald versus City of Chicago, which was the decision in which the court incorporated the Second Amendment, made it applicable against state and local governments. I say more important because still today, the majority of gun regulation in the United States happens at the state and local level. There are some very important federal laws, including prohibitions on possession by those convicted of felonies, those adjudicated mentally ill. But the vast majority of sort of locally tailored gun regulation, if you like, is still state and local. This is a picture, by the way, of Otis Mcdonald, who was the petitioner in Mcdonald versus City of Chicago. He died in 2014, but I put his picture up here on the off chance that some of you may have known or seen him. He was a janitor and later maintenance engineer at the University of Chicago for many, many decades. In Mcdonald and in many cases thereafter, Chicago's gun laws have been repeatedly subject to Second Amendment challenge, sometimes successfully. And I think it's fair to say that the most prominent prominent judicial critic anyway, of Heller and Mcdonald was none other than native son John Paul Stevens, there on the right, who dissented in both Heller and Mcdonald and devoted substantial efforts after he left the court through op-eds, book chapter, to calling for those opinions to be overturned and for the Second Amendment itself to be repealed or amended. Again, consistent with this focus of sort of blaming, if you like, or focusing on the Constitution as the explanation for the relative paucity of gun regulations in many parts of the country. But, and I hate to sound like I'm taking a different tack than the great Justice Stevens here, but to the frustration of many gun rights activists, the Second Amendment has not yet proven to be a major obstacle to most standard forms of gun regulation. Part of that has to do with Heller itself. I'm giving you a little bit of the language from the opinion here. It blesses as constitutional, or at least as presumptively lawful, a potentially wide range of gun regulations. And in applying Heller, so far, the lower courts have been pretty consistently upholding challenged laws. The success rate for Second Amendment challenges has been under 10% consistently since Heller was decided. And this data is a couple years out of date, but I don't think the trends have changed much since then. I should note, by the way, on this study, actually, that what we counted as successful challenges included interlocutory things like remands. So if you look at just final results, like laws actually being struck down, the percentage of successful challenges is probably even lower. And what that means is that courts involvement has been extremely limited, at least measured by statutes being struck down. It's not that gun laws are being ruled unconstitutional, it's just that they're never being passed in the first place. Again, the biggest reason for that, the biggest explanation, I think, is straightforward politics and interest group politics. I'm happy to talk about that to the degree I can, although I'm not a political scientist. It's not my area of expertise. There are, again, all kinds of complications and pathologies in the U.S. gun debate. But I think, again, it would be a mistake to look past the degree to which law actually creates law itself creates specific obstacles to gun regulation, whether accomplished privately through tort suits or through statutes and regulations. That's true of, for example, special industry tort immunity granted through federal law. It's true of state laws, which limit the ability of private property owners to exclude guns from their property. This is the so-called take your gun to work laws, or sometimes called parking lot laws. And there are other examples as well. The most important by far, I think, are state level preemption laws, which limit or forbid local governments from passing their own locally tailored gun regulations. Now, throughout American history, most gun regulation has been done at the local level, and guns have been regulated much more stringently in urban areas than in rural areas. That is a sort of consistent trend wherever you are in the United States and in whatever period. It's true even of the sort of famous gun havens like Dodge City, Kansas, and Tombstone, Arizona. Here you can see Dodge City's prohibition on carrying of arms within city limits. People were, of course, able to and likely did carry guns on the frontier, but once they reached the city limits, the idea was that you would check your gun so long as you were in the city. And the logic behind those regulations is self-evident, that in crowded urban areas, or even relatively crowded urban areas like Dodge City in the late 1800s, the likelihood and the consequences of gun misuse, including death and injury to bystanders, are simply much higher. And the police or law enforcement are more proximate. In rural areas, by contrast, the opportunities for lawful uses of guns for things like recreation or hunting, which until recently were the predominant reasons for gun ownership in the United States, are abound, and police response times tend to be longer, therefore arguably increasing the self-defense argument for gun ownership. But over the past several decades, pushed in part, it must be said, by the NRA, states have widely adopted preemption laws, which again take away local regulatory authority when it comes to firearms. In 1979, only 7 states had these laws. 10 years later, 18 did. Today, depending on how you count, 44, 45, or 46 states have such laws. Some of the more recent ones, I should say, actually impose financial penalties on local governments or even on individual local government officials for supporting gun regulation that's more stringent than the state standard. Kentucky criminalizes that act. Florida had a provision which gave the governor power to remove from office local government officials who voted in favor of gun regulation that was more stringent than the state standard. These are quite punitive laws, some of the more recent ones. And this movement, the preemption movement, to come back to the original theme, started right here in the Chicago area. In June of 1981, which is a year before Chicago passed the handgun restriction that would eventually be struck down in Mcdonald, the village of Morton Grove banned the sale and private possession of handguns within municipal limits, giving residents until February 1982 to dispose of their guns. And the backlash to this was swift and severe and nationwide, effectively generated the rise of preemption laws that you see sort of charted there at the top. Interestingly, Illinois is a little bit of an outlier here. Illinois still does not have a very stringent preemption regime. There's a little bit of something since the 2013 FOID Act, but the sort of impact of Morton Grove's activities really felt more outside Illinois than they were in. But in effect, the constitutional politics that Morton Grove launched helped create a legal transformation that I think is really on par with Heller itself and should be recognized as such. The picture here, by the way, is from a sort of vintage T-shirt that was marketed at the time among gun rights advocates. Now, this, of course, is all just descriptive, trying to draw attention to what I think is an underappreciated and important part of the story of why our nation's gun laws look the way they do. The next big question, the normative question, of course, is how to evaluate these preemption laws. What level of government should be in charge of what kinds of gun regulations and why? And I have to say, from within the field, this is not a question that firearms law scholars tend to ask very often. The focus tends to be on particular readings of the Second Amendment or the constitutionality of specific kinds of gun laws. One thing that's clear to me from today's discussion is that those of us in the firearms law community have a lot more to learn from those in adjacent disciplines who are working much more fine-grained on the local level. Another complicating factor here, of course, is that I don't think there's a single answer to the question of which level of government should have primary authority here. I don't think it's an either or, states or local governments. People often talk about gun regulation, gun control, and gun rights in sort of binary either or sort of terms, which I think is a mistake. Of course, there are many different kinds of gun laws, prohibitions on classes of arms, classes of dangerous persons, manufacturing requirements, storage requirements, restrictions on modes of carrying, and I think this is really important, the rise of non-criminal interventions, including community-based intervention programs that don't rely on criminal law, increased funding for those, including actually in the Chicago area, in recent years strikes me as a very promising development. The spread of what are sometimes called red flag laws, which are technically extreme risk protection orders, again, a civil intervention, I think also quite promising. I've put up here on the slide just some examples of some kinds of regulations that live on different levels, federal, state, and local. Of course, there's lots of overlap here. I'll just say initially, I think it's probably clear that some rules and programs probably need to be done at the federal level in order to be maximally effective. I think that's probably true of things like manufacturing requirements and background checks, just for purposes of maintaining an accurate database. And I should also note that I think there are legitimate arguments against local control. Supporters of preemption laws emphasize their desire to travel armed across a state without fear of inadvertently violating local laws. And I don't think that's an illegitimate interest, especially in light of everything we know about sort of over-enforcement and carceralization. It's just that interest, I think, has to be considered alongside others, including the interest that urban residents may have in protecting themselves and their loved ones from gun violence with law. So the question comes down to how we should distribute regulatory authority among the federal, state, and local governments when it comes to particular kinds of gun laws. And lacking one overarching answer, I'll just offer a few frames, at least, for thinking about that question. One is the simple sort of costs and benefits of variation and experimentation in this area. This is a familiar standard argument, of course, for federalism most generally, or for localism. It has traditionally been the major argument in favor of preemption, so as to protect gun owners who are traveling across a state from having to navigate what the NRA often calls the legal minefield that would result if cities could regulate themselves as they see fit. You see here just something I clipped from NRA webpage referring to the virulent intolerance that guns and gun owners face from local governments in some places. On the other hand, it has to be noted that jurisdictions might quite reasonably have different approaches to guns just based on context. Where I grew up and where I live right now in North Carolina, it is not at all strange to see people with rifles on the backs of their trucks, even coming to school in the morning during deer season, because hunting is a big thing during deer season around here. But if you see that same truck with the same rifle in a different context driving near the U.S. Capitol or something, it sends a very different message. I think that the idea of just sort of location-based restrictions is actually intuitive, even if people disagree on the particulars. That leads to a second point, which is an argument which is commonly made against arguments against preemption, which is that guns are resistant to local regulation. And again, I think if we're going to use Chicago as our example here, it is illustrative. Chicago has a limited ability to restrict what kinds of guns are available in the city, because things like assault weapons, large capacity magazines, and so on can easily cross the city's borders. And I think that's true for the sort of undermining the effectiveness of lots of different kinds of gun laws. The chart here is from a 2017 CPD report on crime guns and where they originate. And as you can see, most of them are coming from outside of Chicago, a great many of them coming from Indiana. One of the things that jumped out to me from the study anyway is that just the first 4 source dealers on that list accounted for the majority of crime guns recovered in Chicago in that year. So undoubtedly, there are difficulties to enforcing some kinds of gun restrictions at the local level. On the other hand, I think this restriction can be overstated. There are other rules, including those, for example, regarding public carry, especially open carry, that can be enforced on the spot without regard to whatever neighboring jurisdictions decide to do or not do. So a recent example of this, which you may have seen in the news, was that Boulder, Colorado had a prohibition on AR-15s and similar kinds of rifles. It was struck down on preemption grounds, that not Second Amendment grounds, but because it conflicted with Colorado's preemption statute, literally days before the shooting at the King Soopers supermarket. Now, if AR-15s are illegal in a jurisdiction, then a person carrying one through a parking lot, as the shooter did in that case, would be stopped and arrested on the spot. And that strikes me as the kind of thing that at least does support possibility of some local level variation. If such a law proved popular and effective in that locale, then other urban jurisdictions might follow suit. And here, I guess it's just worth noting that 40 years ago, when Morton Grove adopted its law, it was specifically with the intent of providing a model for other jurisdictions. We've seen something similar with the state-to-state spread of those extreme risk protection order, red flag laws. Early adopters like Connecticut got good results. They adopted their law in, I think, 1999. In the last 3 years, more than a dozen states have joined them. We now have about 21 states, I think, with red flag laws. And the third point, kind of the final one, I guess, is just to push back a bit on the constitutional rhetoric behind these preemption laws. Often the things that they seek to protect, like concealed carrying against local regulations, are things that are specifically not covered, doctrinally at least, by the Second Amendment, even under Heller. Now, that doesn't mean it's necessarily illegitimate to invoke the Constitution or to use constitutional rhetoric. I don't think constitutional law is just limited to what the courts do. But I do think it's important to recognize that the gun debate is not just about constitutional interests on one side, that of gun owners, and sort of nebulous policy interests on the side of everybody else. And one thing that the events of the past year have demonstrated, armed protests being one such example. This was a gun rally in Richmond. You all may have seen, of course, the armed invasion of the Michigan legislature, which forced its closure temporarily, is that especially in urban areas where the externalities of gun use are so clear, expanding gun rights often means coming into contact and sometimes tension with other people's constitutional interests in speaking, assembling, worshiping, teaching, and learning, or voting for that matter, without fear and terror. And we're increasingly seeing, I think, even in narrow legal contexts, that there are constitutional interests, cognizable constitutional interests, on all sides of the gun debate. I certainly don't have anything like a single solution about how to resolve that tension, although, as is probably evident, I do think that the current wave of gun preemption laws goes too far in one direction. And I'll stop there.
Great. Thanks so much. So I'm going to open it up for questions now to any of the panelists. Aziz Huck in the Stanford Computational Policy Lab, or LaToya Baldwin-Clark, or Joseph Bloker. I have some questions, but I would really rather that other people ask their questions. So I'm going to try to be patient and give people a chance to raise their hands.
So this is really interesting, and it's really got me thinking. And what really sort of sparked this is seeing the sort of movement of guns and thinking about what LaToya said about how we have enabled the sort of flight of white parents to choose the school, the basically segregated schools of their choice. And I'm wondering if part of the underlying problem here is that we have sort of locked in certain people to certain, to use the phrase from earlier, high crime neighborhoods. Through a variety of mechanisms, we have limited the movement of people of certain people while still allowing the sort of free movement of the tools of violence. And you can sort of consider that those tools broadly, from structural factors to guns themselves. And I was just wondering if anyone had any thoughts on that.
I can say something about that. I think that you're absolutely right. The idea that people have been locked in. And one of the things that I really try and do in my work is that this is particularly the case for children, right? Parents can get up and move their children if they want to, but children generally don't have much agency when it comes to where they live, where they go to school, any of those things. And, you know, because they are locked in, because there is this spatial oppression that is happening on their bodies, these tools of violence, they're just so much more susceptible to, because they can't get away from it. And so, you know, that's how I've been thinking about the problem and the process. But yeah, I think that you're right that those are like kind of the two dynamics that are happening. People can't get out, and if they can't get out, then they cannot escape the different structures of oppression that are leaving them susceptible to being victims of violence, but also to being perpetrators of violence. And both of those things, I think, are a problem, of course.
And if I could just echo, I think it's a great question, a great observation, Adam. And I just want to amplify again something that LaToya said, which I think is really, really important and really insightful, which is that we're really doing a disservice, I think, including even in my little narrow corner of the world of gun regulation, if we just focus on the sort of direct violence costs, right? The debate in gun circles tends to be focused on the truly horrific numbers of people who every year are killed or injured by bullets. And last year is about 40,000 people died. Most of those are deaths by suicide, about 100,000 people injured, right? That's an astonishing carnage of just bullets and bodies, and it makes sense to focus on it. But it actually is radically, I think, underestimating the harm, call it violence or whatever else, that people suffer. One thing that stands out to me consistently is this: CNN has like a running header where they count the victims of school violence, and the number's like 300 or something like that, because they're just counting the number of people who've actually been shot, right? And it's not taking account of every other person who was in a school that was subject to a school shooting, or who lost a friend, or who's traumatized by an active shooter drill, or, to take LaToya's word from a minute ago, the susceptibility is a harm. Rita Siegel and I, in some recent work forthcoming at Northwestern, are trying to make clear that this kind of broader conception of public safety is actually also supports, in proper cases, the case for, again, appropriate gun regulation. So just to echo, great question, Adam, and I just want to again amplify LaToya's point there.
Other questions?
I was just going to make a comment. It's not quite the same thing as a question. Okay. Well, that was very, I think even the larger implications of Aziz's work with the Stanford crew on the substitution of traffic stops and things. What it really illustrates is the fungibility of policing tactics. You can move from one to the other. You can hope for the same effect. You can hope for better effects in different kinds of places. And one place this overlaps is with discussions of the Ferguson effect. So we hear a lot about police withdrawal, okay, being the cause of enormous explosions and violence. So Paul Castle's group at Utah, in their impact, the collapse of stop and frisk, said it was because the cops stopped doing things. The cops stopped stopping people. They stopped, but all you have to do is dig through the data that's available from the 911 center. What you see is they started doing all kinds of other things instead. So it's, and as their research, I think, is showing, the traffic stops, the traffic stop grew very quickly to be the same volume as the prior stop and frisk. So the fungibility of it, it seems to me, is often too subtle for people who are trying to figure out what the impact of stop and frisk is, or trying to figure out what it is that led to a spike in crime and ending up with the Ferguson explanation. I've geocoded the Chicago stop and frisks, and I've geocoded the Chicago traffic stops. And what you see is it's not just in the levels. Aziz's chart showed how stops came down and traffic stops went up, but at the micro level, at the block and the block group, they're in exactly the same places. Not only did the volume of stops simply switch from one tactic to the other, they were targeted at the same places. It was the same concerted, planned, hotspot-oriented, aggressive enforcement, but it disappeared when it became traffic stops, whereas before it was stop and frisk. So the researchers need to be quite attuned to the fungibility of strategies, and the problems of focusing on one is that they pop up other places.
Could I make just a quick responsive comment to that? But Alex or others should jump in too. So Cassell's specific argument was that the consent decree reached between the city and the ACLU caused caused the decline in stops, and B, caused the concomitant increase in murders that occurred in the city in 2016. And I think that claim is complicated both by the substitution effect that we show here, as well as the well-known New York data, which demonstrates the very, very sharp decline in stops that accompanied the implementation of the Floyd decision at the beginning of the de Blasio administration. Did not lead to any change in crime. But I think that there's an important linkage between this point and the discussion that Robert Vargas had this morning. And I would put the point in two ways. The first thing is that the city of Chicago had available both the data on street stops and traffic stops. It was publicly available if you looked, and we and Wes and others have looked at it and are able to draw inferences from it. But the city was making claims about the decline of stops leading to the increase in crimes, notwithstanding the fact that they had the information available to them that demonstrated that there was no decline in policing contacts, at least of the magnitude that they were advancing, occurring at that time. Right. So this is a point about control of data, or maybe the ability to put two pieces of data together in a way that draws inference. The second observation I would make is that the narrative or the assertion that the ACLU's agreement was the cause of the rise in murders, and maybe this was an allegation that I'm particularly sensitive to because I was involved in drafting that agreement, was taken up by the University of Chicago's crime lab and was advanced by the crime lab in a number of presentations that I saw. And the questions about the relationship between the academy and social sciences and police departments or governments in general that Robert Vargas raised, I think, are underscored by that dynamic.
One last thing I'll mention, just to sort of tie the loop on a couple points, is that very similar pattern appears in Philadelphia, pretty much under the exact same circumstances, where there was some agreement with the city to reduce pedestrian stops, and they did go down, but traffic stops appeared to go up over the same time frame. So something that we think could be happening in other places. And on that point, and to this point about data, we've tried to look at sort of other cities that are under some version of a consent decree or some kind of agreement, and it's been pretty difficult for us to get a complete set of data for other jurisdictions to answer this question, whether this is more widespread.
And I'll just add one more thing about the fungibility of policing tactics. So one of the things that I'm trying to show with school districts is that many times school districts will actually hire ex-cops to go about the business of surveilling and targeting parents that they believe don't live actually in the district. And so it's very much taking these same types of logic about crime and criminality, especially with poor Black people, and putting it into the school district context in a way that we don't often talk about. We talk about the school to prison pipeline, but we don't talk about the actual ways in which we use criminal justice in order to keep people away from opportunities.
All right, I'm gonna come in with mine. So I have one question for each presenter or group of presenters. There's a sort of a technical question, a conceptual question, and a descriptive question. So I'll go in that order. I guess the first question is probably best directed to Alex. I know that the figures you showed us were a sort of grossly oversimplified version of what's in the report. But I'm curious about the figure that showed, I think this was the Nashville data, where you showed the traffic stops plummeting and crime doesn't change. And I think as an audience member, I was led to infer that traffic stops have no effects on crime, but of course, we don't know what the counterfactual looks like. And I'm just curious in the report if you have the ability with the data available to you to get at the counterfactual. Maybe if traffic stops had stayed at the high level, then crime would have declined, right? Who knows? maybe the Nashville Police Department felt comfortable easing off on the traffic stops because some other conditions were improving in the city that made them feel like crime was going to stay stable. So that's the question for you. For LaToya, I have a much more conceptual question, and it's about the word violence. And this is something that I've been sort of turning over in my mind since long before I heard your presentation, but I was thinking about it through your whole presentation. And I've commented to friends on the faculty about what I perceive as sort of almost a generational change in the way we use the term. And our students, you'll hear things like words are violence, or words can do violence, right? And I think about literally how, like, I was taught sticks and stones can break my bones, but words can never hurt me, right? And I am completely on board with the use of the word structural in your phrase structural violence, and I'm completely on board with the reality that the forces you describe are incredibly harmful in constraining opportunities and so on. But I guess I'd like to hear a little bit more about why the word violence. And I looked up on Google the definition, and it involves both physical force and intentionality. And I'll notice, I don't want to put him on the spot, but I'll notice that when Joseph was alluding to your paper earlier, he said something like, we'll call it violence or whatever else, right? And he's sort of varied between the word violence and the word harm, right? And maybe, again, he can tell me if I'm wrong, but maybe he felt some of that same, I don't know, confusion, or had some of the same question in his mind that I did about, so why violence? And then finally, Joseph, my question for you is mostly just descriptive, although, feel free to riff on it, which is, what is the role today of private regulation of gun ownership and possession? So living here in Chicago, right, you often see when you go into a business, you see the sticker in the window that I think is required by law. Businesses, I believe, are allowed to prohibit you from entering if you're carrying a weapon, but they have to display this sticker, right? And it's a pretty well-rehearsed argument at this point. We started with Pruneyard, and the shopping mall is the new town square, and now we've got Facebook as the new town square. And I'm just wondering, so much of the land we walk on and the property we find ourselves on is privately owned. And I'm wondering whether, as a descriptive matter, private regulation of gun ownership is important. Is it our future? Are states or localities moving to do very different things from what Chicago is doing, and in fact prohibit private businesses from prohibiting patrons or visitors from possessing guns, or what that looks like? Okay, so those are my three questions.
Yeah, so I'm glad you asked this question. In the interest of time, we did keep it at a pretty high level, but to provide a little more clarity on the sort of stated goals of the policy, the mechanism that the department had proposed for traffic stops preventing crime was this notion that I think the concrete story was like that you might happen to pull over somebody who just committed a burglary, was about to commit a burglary on their way to and from the crime scene. The notion was sort of that they almost certainly would be driving a car. And so that was the sort of idea, is that you could stop these things from happening either right before or, catch them right after, or something along those lines. Which, sort of, I'll note that, like, personally, seems like a little bit of a stretch to me, but that was really the stated theory for how this worked. And so one alternate way that we looked at it was to see whether these increases in deployments, in particular in the short term, so in the span of a week or so, corresponded with any kind of rise or drop in crime. And there's some technical details which we talk about in the report that allow us to consider that assignment of stop to be somewhat random, which allows us to make some inference, basically some causal inference, to say in situations where there's a lot of stops happening, do we see any connection to increased or decreased crime? And it turns out that, like, when you look at that regression line, when you try and understand whether there is this relationship, it's basically nothing. It's extremely flat. So the sort of takeaway there is that in the short term, regardless of how many stops you apply to any given area, it doesn't affect the number of crimes that happen. And so this is really sort of a much more direct analysis of the policy goals as stated. There were some lucky things that let us sort of take this randomized assumption, and that allows us to sort of make this point in the short term. That long-term chart that the chart that I showed you was just a sort of an additional, accompanying chart to say, look, we see this happening in both places. It's pretty unlikely that there's any effect here. And that, that long-term chart, I'll also note that, as has been mentioned, that same kind of pattern exists in many other jurisdictions, like in New York with stop and frisk. You see the same exact thing where you see a pretty dramatic drop in this policy and no real sort of significant change in crime.
I think that you're right. I think that the term violence can have, I don't want to say many definitions, because I think that would be kind of a cop-out to say it has many definitions. But what I do think is that what the term gets us is to stop being preoccupied with violence that acts directly on the body from one person to another through some particular action. And I get your point about intentionality, but I would argue that many of the structures that are there for oppression and violence are intentional, right? And so we can look to the ways in which these laws have been set up to intentionally keep people out, right? To intentionally make it so that their life chances are not as great as someone else's life chances. They have intentionally have been made to decrease the life expectancy, right, of Black people and particularly Black men. And so when I think of violence, I think what I'm really trying to get at is the threat, right? There's this threat, the distribution of death, the distribution of how people come to the end of their lives and what the quality of that life looks like. There is, I don't know if I said this already, this structural violence comes out of peace studies, with the idea that the difference between that peace is on one hand and that violence is on the other. You can only have peace if you have the absence of violence. And if you have violence, then you don't have peace. And I think that's actually pretty positive in this context. As you all know, there's often when there's been a police shooting, any kind of shooting in Chicago, there'll be people that come out and they have peace marches, right? Very much that the way that we get to peace is through the absence of violence. And what I would say is that we cannot talk about peace as if it only means that you are not being killed by bullets, as what Joseph says, right? We need to have a more expansive idea of what it means to be peaceful. And if I want to put as the counter to peace, I'm going to call it violence. But I think you're right. It's something that I'm going to have to be very careful about when I write the essay, of really defending why I'm using the word violence. But I do think that it can work here with a little bit more kind of explanation and really kind of pulling it out.
If I could just briefly follow up. I take what you say with respect to intentionality. And I basically take everything you say. It makes sense to me. There are times in your talk when it sounded like violence could encompass things like constraints on opportunity. But now in your response, it sounds a little more targeted to the sort of threat of harm. You said the risks to life. And I think that actually makes it register for me. And I would just mention that if you think about the crime of assault, this is the way we talk about it, right? It's actually quite confusing for first-year law students when they're like, wait, I thought assault was when you hit somebody, and you're telling me assault also includes times when you make someone feel in fear of being hit, right? And I think there's an analogy there. So,
thank you. That's really helpful, actually.
And I'll just jump in here because I think this question is fascinating, and the exchange that John and LaToya you just had, I think, is really illuminating. You're very perceptive to caught me on that moment, John, about sort of not knowing how to use the term violence. I should confess, I led a reading group in the fall here at Duke on law and violence, most of which was trying to figure out, like, what do we mean when we talk about violence? And I left it more confused than I started. I think it is an inherently normative and contested concept. There are those, Wolf has a great essay arguing it is just a useless concept because it's so contested. It's just purely normative all the way down. I think there are others. Cody, C-O-A-D-Y, had a good essay, I remember, and sort of map things in a way I could follow, of sort of like there's overt, there's covert, there's personal, and there's institutional, and those 4 boxes kind of give you ways to think. What you all were just talking about there, sort of like the bullets and bodies, like, physical carnage version, and then the risk that, sort of attended there, those to me travel together pretty well for exactly the reason you say, John. We understand assault, we understand that brandishing can be a violation of the law, even though, open carry isn't, or whatever, like in the world of guns. The only thing I would add to that is that the kinds of structural inequalities, harms, violence, whatever you want to call them, that LaToya has identified are often based historically on very real physical violence. And once a system is set up using violence that meets any definition, it may not require much more violence to keep it going. In the sort of way that, like, Robert Cover and others have written about, like, legal interpretation takes place on a field of pain and death. It doesn't mean that every time, anyway, you guys see where I'm going with that. To your particular question, John, about private regulation of gun ownership, I think this is an enormously rich and important area. I'll answer just say a few things quickly about it. One way in which private regulation of arms in particular could matter is through private law, tort lawsuits, for example. And for a long time, that actually was a major way in which guns were regulated. Municipal lawsuits against gun manufacturers for things like negligence, huge thing in the 80s and 90s, really an existential threat to the firearms industry. Chicago, again, involved as a plaintiff in many of those cases. Those are basically brought to an end by 2 things. One, the passage of what's called the Protection of Lawful Commerce in Arms Act, or PLACA, which is a federal immunity statute, which basically immunizes sellers and manufacturers of guns from most tort lawsuits. They can still be sued for things like negligent entrustment, but for the most part, it's an immunity provision. And the other thing is the preemption laws. And in fact, a lot of the recent preemption laws were put in place specifically to keep places like Chicago and Gary, Indiana, from trying to get through tort lawsuits what they weren't able to do, or what they might otherwise have tried to do through local regulation. The one big case to watch there is Soto versus Bushmaster, which is a post-Sandy Hook lawsuit being brought against Bushmaster, who made the rifle used by the shooter in the Sandy Hook case. The second thing, though, and I think this is what you're asking about, was sort of like private choices made by private actors, like, sort of the equivalent of the mall cases from the First Amendment. There's some really interesting law. There are in some states what are called, and I mentioned these just briefly, take your gun to work laws, or parking lot laws, which say that private businesses have to allow, especially employees, to bring their guns to work, even if they have to keep them locked in their cars, which I and others have argued violates a variety of constitutional interests of the private property owners. I have a piece called The Right Not to Keep and Bear Arms, where I actually argue it violates their Second Amendment rights. They've been challenged on takings grounds and others. There were a few cities out there, including Kennesaw, Georgia, which legally required private homeowners to have guns in their house. Never enforced, but in any event, that was eventually repealed in the last couple of years. And then the final thing I'll say on that, on the private, call it regulation or not, is the most significant thing in some ways are the decisions that companies are making about which kinds of guns they're willing to manufacture or sell. And so when you see places like Walmart or Dick's Sporting Goods getting out of the market, or Salesforce.com getting out of the gun market, that presents a totally different change, a shift to the way that gun sales happen, which may ultimately be more significant than like any individual sort of municipal regulation.
Great, thanks. Danny?
Hi, so this may be more of a question for Joseph, although I think it touches on a variety of things that everyone has been speaking about, so I'd be curious on if anyone has thoughts or examples. But when it comes to the questions of gun regulation and constitutional challenges to gun regulation, so this is not at all my area of expertise, so I'm coming at this from a largely lay perspective. But I've observed, in other types of cases involving constitutional challenges and politically contested issues, like abortion or gerrymandering, there is a resistance by some courts to engaging with more complex causal social science as in evaluating the strength of various compelling interests, or non-compelling interests, the strength of various interests. And I wonder and I also, as a layperson, have observed just in sort of popular press, what seemed to me to be increasingly evidence-backed and sophisticated analyses of gun violence and its implications. And as part of the case for or against various kinds of regulation over the last decade. And I wonder whether in courts you see either a resistance or maybe just a lack of facility to using these complex causal claims or more evidence-backed claims when it comes to evaluating different interests. And also, maybe more generally, what the relative weight is of factual evidence as opposed to more normative or doctrinal analysis when it comes to sort of emphasizing particular interests or weighing certain interests as in versus out.
It's a huge question, Danny, and a really fascinating one. So I'll try to give just a thumbnail answer because I know we're a little bit short on time. Weirdly, it seems to me actually things are happening differently in the Second Amendment context in that, again, most courts are upholding most laws and there's not a lot of laws are being struck down. Of those that are either close cases or those where laws are struck down, it tends to go the opposite way, that courts are demanding empirical evidence, which is very hard to produce because it's just hard to, to find, to get the right regressions to show that loosening a public carry restriction, for example, led to more deaths or not. Now, there are wonderful empiricists out there who do that work. John Donahue at Stanford, Phil Cook, my colleague here at Duke, do fantastic. Jens Ludwig, of course, do fantastic work on these questions. But a lot of courts have said, hey, it's hard unless you can show me that this gun law saved lives. I'm not going to uphold it. It's the government's not carried its burden under. It's usually applying intermediate scrutiny. It's actually one of the reasons why I think that the point that LaToya and I were just talking about is so important, is that so many of the harms here are being sort of misconceived as just bodies, and you're missing this enormous sort of, like what about the attrition rates, the absenteeism in schools where gun violence happens? Great evidence for that, and that actually attendance rates go up when stronger gun policies are in place. That should, in my argument at least, that should factor into the calculus as well. Those are things that the government has interest in encouraging. But so far, it's hard to say. And then I should just say, just finally, the court recently, as you may have heard, took cert in a Second Amendment case, which the justices will hear next year. It is, I think, the major question in that case will be the methodological question of how courts will continue to evaluate gun cases going forward. And I can imagine at least 4 votes, maybe 6, for the sort of ascendant test that Justice Kavanaugh and others have championed, that gun law should be evaluated solely based on text, history, and tradition, which would seem to make no room whatsoever for the empirical evidence. And we'll see what happens with that.
Great, thank you so much. Robert Bornholtz, I'm sorry that it's 3:01 and I'm going to keep us on schedule, but maybe you could reach out to whichever panelists you had questions for by email. So that is the end of our day, and I want to thank everyone for attending, for sticking with us. I thought it was a strong finish here, and I'm just going to hand the mic over to Caroline Venero for just some very brief closing remarks, and then we'll set you all on your way. Thanks again.
Hi again, everyone. On behalf of the University of Chicago Law School, and particularly the Law Review, we just want to thank you again for coming. It's been a phenomenal day. We're so excited about the scholarship we saw today, and we're even more excited to see it in print in March of 2022. So keep an eye out, and for our panelists, we'll continue to stay in touch about what drafts and editing will look like. So I just wanted to say thank you all again. Have a wonderful rest of your day and weekend. And thank you for coming.